Honorable Minister of Justice, dear participants of a discussion, viewers, our remote participants. My name is Mārtiņš Daugavs, and I am truly honored to welcome you to the conference, The Role of the Judiciary in Economic Development. This conference is a webinar format conference gathering specialists of the sector. It is organized by the Ministry of Justice in collaboration with the court's administration. The aim of the discussion is to foster a debate among professionals of the justice sector regarding the practical support provided by the judiciary to economic development and attraction of investments. And considering that a properly functioning judicial system promotes the proper functioning of the market, our task today is to take a broader look at the practical tool and the efficient application of them, as well as the improvements that could be done in the justice system to promote economic development and national development along with that. According to the EU Justice Scoreboard, the main features in an effective justice system are efficiency, independence, and quality. And based on these fundamental values, we will organize our discussion. The first part will be more about the framework of the system, and the second and third part will be more focused on investigative actions and improvements. The real host of this event is the Ministry of Justice, so it is my honor to give the floor to the Minister of Justice, Mr. Jānis Bordāns. Hello and welcome, ladies and gentlemen, and viewers that have logged on to view our discussion through modern technologies. First of all, I would like to thank everyone who is joining our panel today for their contribution to the development of the justice system in this very difficult time. The state is us ourselves. We are the ones who can promote the development of our state if we look and work together. That is the main task of our discussion today, to discuss how the justice system and national welfare is interlinked and how it can promote the development of each other. As of July 1st, 2016, Latvia is a full-fledged member of the OECD. This organization unites the most developed countries in the world, and from becoming a member of the organization, a lot has been done. We have ensured transparency for the business sector, and a properly functioning justice system is very important as it ensures the transparency of case law. And by joining the OECD, Latvia already gained certain benefits and advantages. It was a driver for additional reforms in the business sector and justice system, a driver for the fight against corruption. And in the context of the Moneyval recommendations, our main task is also to improve the transparency of the business environment and improve our fight against economic and financial crime. A special focus is placed on establishing a court for financial crime, which will give a significant contribution to furthering these types of proceedings. In the recent years, a lot has been done to improve the efficiency of court proceedings, and the state Review Office last year began an investigation on an audit on the work of the justice system in terms of investigating various economic and financial crimes. And these improvements to the system will improve the investigation quality as well as efficient use of resources. About a year ago, the Ministry of Justice held a discussion on the efficiency of commercial proceedings, and justice system, and it was found that the system does have various tools at its disposal, but they are not always efficiently used. Various differing decisions taken by courts show that tools are often used discrepantly, and this therefore is an issue not only of legislative amendments, but also the application of existing legislation. Reducing the formalism of application of legislation and the collaboration between various institutions is one of our main tasks. And the changes in the court system are to a great extent based on changes to the appeals system, and a properly functioning justice system is a guarantee for the rule of law and the trust by the people in the justice system. Thank you to the Minister of Justice, and now we can move on to the first panel, which will also be joined by our minister. Just a couple of technical issues before we move on. You are watching us through Zoom, and throughout the conference, we will occasionally also have discussions in English. If you need an interpretation, then you can see a little Earth icon on your screen, and if you click on it, then you can choose the language in which you can hear the interpretation. If you do not see this icon on your screen, then you might have the previous version of Zoom. So if you already have Zoom installed on your computer, then you can reinstall it in one of our coffee breaks, and then you will be able to see this interpretation option. So this is a technical issue, but it's easy to fix if necessary. Now about questions. You can ask your questions through WhatsApp by sending them in to the telephone number 28346531. The telephone number will also be displayed on screen. So please do feel free to ask your questions, send them in. We will look at them throughout the discussion, so you can see the telephone number on your screen now. Now that we've covered the technical issues, we can move on to the first part of our discussion, the topic being the role of the rule of law in the national economic development. And our first speaker is Irene Kutsin of the State President's Chancellery. Then we have a representative of the Constitutional Court, and obviously our Minister of Justice, as well as Tatiana Teplova of OECD. I hope that Tatiana has been able to hear us. And now we will begin our discussion with a brief 7-minute presentation by each of our speakers that have not yet had a chance to speak.
Colleagues, good morning. I am very glad and honored to be here in front of you in these rather bizarre circumstances and to give my and our president's point of view as to what rule of law and justice is, who and by what, which means it is formed and how it can be strengthened even more together. And after this conference, when going home or to work, we can think further what within the framework of our respective institutions we can do about it, about strengthening it. Lately, in public discussions, very often we are talking about what justice is, that we lack justice. We speak about enemies of justice, culture of justice, but what do we understand with the word, the notion justice? Is it just a notion that we consider to be important, but somewhere far away? Or can we feel it and reshape it in the daily life? in our daily life or nationwide. It is difficult to measure, but how to approach it? It is connected with public processes, which can be captured by the law, giving possibilities, responsibilities for each and every one. By law, we have to understand every piece of legislation, including application principles. Those elements form system of justice. Another significant element is expectations of public expectations of the society. We believe or we rely that everyone is going to obey the rules, and that on a specific cases, law will be applied and certain principles will be applied. I would like to stress that not just a piece of legislation, but a system together, where according to a certain methodology, an applicable rule can be found. Justice and rights is not all. Many areas of our life are not dictated by the law. In a democratic country where the rulers are us people, certain specific areas are being regulated by the law, the others by us ourselves. It is one of the main principles of democratic society, contrary to authoritarian countries. Authoritarian or totalitarian countries are trying to dictate all areas of life of people. But in democratic society, there are certain boundaries dictating or specifying boundaries. Freedom of act has been encaptured in our basic legislation, Article 18.9. Justice means that the law has been applied without any deficiencies, and our president name them, those deficiencies, without deviating from the law, without neglecting the law, without prejudice. Justice is connected with the quality of law, and the quality of law is formed by rationality and justice of the law. Rationality of law prescribes how efficiently the problem can be solved. Very closely linked with it is justice. Justice can be achieved by a law, but a good law has to be efficient and just. According to me, the quality of law and justice are kind of crippled or mitigated the number of amendments. Amendments make us uncertain, and it doesn't allow to apply common practice. Many people think that justice, that a judge is not flexible and cannot adapt to ever-changing laws, but that makes application of law even more difficult and makes us farther from fast achievement of goals. And at the same time, other players think that they do not have any role to play. That's why they go the easiest way and apply law in a formal way, which again requires many amendments. That brings us to this forever going wheel around, and consequences are the following, very negative. A lack of information as to what has been prescribed by the law or yet another amendment. How does this law or amendment is interpreted and how it falls within the framework of existing legislation. And as a result, the society is no longer certain about its rights, and they do not believe in the adopted laws, they do not believe in the rule of law and justice. Colleagues, the quality of law impacts us all, our daily life, from the fact of whether the law is just and rational, and whether we have eliminated drawbacks of the law. Our quality of life is prescribed. For example, entrepreneurship environment. Can we, for example, imagine a situation, investor would like to invest in a country, and he or she rethinks whether there are risks of corruption, there are dubious banking systems, one's obligations are difficult to reach, then justice system. Justice system has to be well functioning, and strong justice system is a key of safe society. We have to be sure that that courts act smoothly, implementing our rights or ensuring our rights. But sometimes they cannot do that. Sometimes they cannot fulfill this obligation, thus influencing economy, which is directly linked with the justice environment. Next example, health of society. Which is a precondition for well-functioning society. But at the same time, the law applicable safeguarding the health of society is one of the most important laws, and which that is especially true right now. If our health and health issues are crippled by deficiencies, and yet another amendment, more certainty will be there. Very many who work in the justice system look at these issues every day, and our conclusions are very harsh. About 50% of our society do not believe in our justice system. In Estonia, about 60% believe in their justice system. In Scandinavia, about 80%. In Croatia, people believe in court systems only by 20%. The overall indicators amongst the European countries have been measured by survey. According to Latvian judges who took part in this survey, consider that social networks, as well as government, as well as some deficiencies, are the impeding factors. But have we made analysis based on this survey? Why we receive these kinds of answers from judges themselves and from the society? Especially from judges who held justice in their hands on a daily basis. We receive these statistics every year, but it stays the same year by year. At the end, I would like to conclude that by ensuring, for ensuring justice, the law, the society, and the those who apply the law should consider the law and justice to be a uniting factor. We should fight against deficiencies, and we should believe and start believing that the law and justice is the basis for our future, and let us safeguard and make them better. Thank you. Thank you, Madam Kucina, representative of President's Chancellery. And now I give the floor for the introductory words to Jānis Neimanis, our Constitutional Court. Please, the floor is yours.
Thank you for giving off the race to me now. In preparation for this 7-minute introductory address, I thought about what I should begin with, because there are various aspects involved in the role of law, in the role of the rule of law in economic development. But I think that there are basically 3 main points that we have to cover today. And so I concluded that we used to have Article 82 in the Constitution, the text of which was completely different from the existing one. Before the law and courts, all inhabitants of the country, all citizens are equal. At the moment, Article 82 is formulated very formally, and it only defines the structure of the courts. So what we have lost is a very important principle, which there's obviously a reason why it is at the beginning of the section on courts. It is the principle of equality. And this is exactly what our citizens expect, what our businesses expect from us, so that the state would treat us all equally. We want competition to be fair, not only in business, but also in choosing your job, choosing a profession, choosing education. We want to be treated equally. We want the state as the regulator of the market to treat everyone equally. We want the state as a market player to be equal to everyone else, to have the state act equally towards anyone participating in public procurements, to ensure that in disputes, the state as the holder of the dispute resolution structure treats everyone equally. This is a central value of a democratic state. And this too is the answer as to what the rule of law is and what it means for economic development of a state. The next article in the Constitution is number 83, which states that the judge is independent. And this further defines how the principle of equality is applied in real life. It means that the judge is subject to the law rather than the instructions of any other person. The judge can only act within the law. They cannot go outside of it. They must base all of their decisions on laws. They cannot base them on anything else. This is the central element if we are speaking about the rule of law in the context of national economic development. Secondly, what is the rule of law and what is the specific meaning of it? We can see this in a comparative sense. I have had the honor to have visited several Central Asian countries. For example, Turkmenistan. We know that it is rich in gas resources. It is actually one of the richest in this aspect in the world. But at the same time, it is a desperately poor country on the verge of despair. And why is that? It's because they do not treat everyone equally. There are the rich, there's the rich social group, and then there's everyone else. From this example, we can see that these wealth laws do not, or laws based solely on wealth, do not give the necessary results. So they have the principle of the rule of law, the very loud fight against corruption. But has this changed anything? No, because even the best laws, the best legal amendments give no results if there is no rule of law, if there is no one who actually wants to apply this in real life. So the next element after the principle of equality is the need for people that want to achieve the rule of law in their daily life. So this is the only way to actually make it a part of real life. We've seen in several examples in Latvia where we've lacked this desire for application, and the only thing that has been achieved are legal amendments, but have they actually given any tangible result? We have many good laws, such as the criminal law, which denotes liability for fraud and so forth, but have we had any cases where we've actually prosecuted the so-called illegal commercial takeovers? We see this happening in the company Ola Farm at the moment as well. This legal, or rather this these legal amendments that have been introduced years ago have not been actually applied in real life, and the illegal business practices that were introduced in the early 2000s continue to be used. So there have been cases where people have abused arbitration court decisions to their advantage. We see that any decision of a court is very important, and this demonstrates to the rest of society that the laws do have meaning, that they have to be adhered to, and the principle of equality applies to everyone. And thirdly, does the rule of law always require an actual law? We live in an interesting time, and actually this is a very challenging time for the concept of the rule of law. We see this every day. We see this in society every day, for example, with the wearing or not wearing of face masks. There is one group saying that we're not wearing a mask until there's a law in place defining penalties for not wearing masks. And there is another group that says that they are wearing the masks because the experts say that this is safer than not wearing them. So what we see here is that sometimes where we could have a law, we actually use our rationality. And so the answer as to whether we always need specific laws in place is to assess whether this is something that could be resolved simply through rational thinking. For example, in the countries where people are more rational, economic development during the pandemic has recovered quicker, and the restrictions have been lighter. So what we see is that the rule of law is not only the written law, it is also the rules established by just rational thinking. In our own Latvian example, we see that amendments to the criminal procedure law establishing restrictions or the rights that could be used would not be necessary if the parties to a court proceeding and the court itself would use just a rational approach and not only base their actions on the written law and written regulations, but would also just approach it with a rational point of view. This also applies to the second question that we will be covering today about the length of producing court decisions. We do not necessarily need to stipulate in law that you cannot write a decision for 8 months. So what does a judge actually do for the 8 months? Is a decision in a small criminal case really worthy of a doctoral dissertation? So in order for our national economy to develop, we need to abide by the principle of equality. Secondly, we need to abide by the fact that our actions have to be based on rationality, not just the written law. And thirdly, each and every one of us in our daily life, we need to apply the rule of law, not only refer to it. Thank you. Thank you, Jānis Neimans of the Constitutional Court. And now we will switch over to our remote participant, Tatiana Teplova of OECD. Tatiana, are you connected with us?
Yes, good morning, everyone. It is a great pleasure for me to be connected to this conference.
Labrīt, liels prieks jūs arī dzirdēt, un attiecīgi šajā brīdī.
I am glad to hear you, and now the floor is yours in English.
Excellent. Well, thank you so much. And again, it is my great pleasure to attend this event with such distinguished panelists from across the Latvian justice system, and also to reflect on the crucial importance of the rule of law and effective justice performance in the midst of the current crisis, and also to strengthen the case for effective justice performance. So as many of you may know, the rule of law is a basic requirement for the OECD membership. It is also a necessary underpinning for the achievement of many social goals, societal goals, and there is indeed evidence, as a number of the panelists before me mentioned, that investment in the rule of law, including effective and accessible justice for people and businesses, can help drive inclusive economic growth. So let me highlight a few points from the OECD conclusions based on the research around the world. First is that there are increasing costs and also significant costs that are associated with the inability of people or business to claim their rights or resolve their disputes. For instance, the recent OECD white paper on building the business case for access to justice shows that annual costs, and here we are talking about annual costs related to the inability to resolve a dispute, to access justice, which is, unresolved legal problems and legal disputes, so this legal cost can go as high as 3 percentage points of GDP. Countries in which we looked. We also anticipate that these costs can actually only increase in light of the current health, social, and ensuing economic crisis, as well as ensuing increase in the legal problems that are faced by people and by companies. We also find that unequal access, inability to access justice may perpetuate existing inequalities in other areas, including educational attainment, health conditions, and employment opportunities. And all of these are important determinants of growth and well-being. And we actually see is a correlation between unequal access to justice and broader socioeconomic inequalities. And to this end, actually, the OECD framework for policy action on inclusive growth highlights that responsive justice, accessible justice is really essential in order to be able to invest in people and places that have been left behind in order to promote inclusive growth. Second, the OECD work also highlights, and actually increasingly the economic surveys of the OECD, such as the economic survey of Latvia, which was the latest was in 2019. So this work finds that a functioning rule of law and justice systems contribute to thriving business environment and longer term investment decisions. And in particular, the OECD is currently working on the new brief on the economic case for effective justice, which shows that the, again, effective justice system in particular, but then rule of law more broadly, essential factors to foster legal certainty and predictability, and thereby support private sector growth. And here we can highlight that, for instance, the rule of law can support the security of property rights, which can in turn also strengthen incentives to save and invest, and also protect the returns from those activities. And then in turn, we see that the secure property rights can be associated with better financial and economic outcomes, such as greater use of external finance. In parallel, what brief also shows is that robust justice systems are crucial to ensure good enforcement of contracts, which again, in turn, can stimulate companies and other stakeholders to engage in economic transactions and economic relationships, which in turn can have an impact on growth through different channels, be that competition, promoting competition, fostering specialization in more innovative markets, contributing to the development of financial and credit markets, and facilitating the growth of specific firms. Some of you may be familiar with the OECD investment toolkit, which actually recognizes the importance of good justice systems and the rule of law in the promotion of the enforcement of contracts, and that this enforcement is really fundamental for markets to function properly. And also another framework for policy action on investment of the OECD suggests that when elements of effective and efficient justice are missing, so when there is something lacking in the justice performance, then companies, and in particular SMEs, meaning small and medium enterprises, can actually limit their activities, so they can limit their economic transactions. And in our research, what we also observe is that lengthy trials, and this was actually evoked by the previous speaker, but that lengthy trials can impede access to justice and compromise the certainty of the justice system. And some of you may remember that when the OECD has worked on the report on access to justice for business in Latvia, we conducted the legal needs survey with over than 300 businesses in Latvia, which reveals that the length of time appeared to be one of the main impediments for businesses to resolve their disputes and actually accessing the justice system. And what we've heard in Latvia, but also something that we observe more globally across the OECD membership, but then also in many partner countries, that inability to timely resolve and address disputes can in turn have knock-on effects on businesses, and again, in particular on SMEs, small and medium enterprises. And in fact, for SMEs, this may lead to the closure of their activities. And this is particularly significant given that across the OECD membership and also in Latvia, the SMEs constitute over 90% of all businesses. So this is really, really an important consideration for the Latvian state, and then of course for the policymakers. And the final point I'd like to highlight on, yes, what we call a business case space for effective justice and for the rule of law is that the length of trial is also related to the confidence in justice system. And again, this was already mentioned by the previous speakers. For instance, the OECD analysis that we've done several years ago shows that 10 percentage points increase in the average length of trial can be associated with a 2 percentage point decrease in the probability to have confidence in the justice system. So in other words, the longer the trials, the lower the confidence in justice. From this perspective, and when it comes to Latvia, certainly from the OECD side, we are delighted to observe and support developments in Latvia in improving the overall quality of the justice system and the rule of law more broadly. For instance, we know that Latvia is working to simplify its statutory, regulatory and administrative frameworks to improve justice efficiency and also to provide justice services in a user-friendly manner. We also know that there are significant efforts going forward to establish the Economic Affairs Court and also to make the justice system more broadly to be more responsive to the needs of business, but then of course also of citizens. And this has a strong potential to accelerate growth in Latvia. And actually, maybe to mention briefly that the establishment of the Economic Court is consistent with the recommendations that were provided in both the Economic Survey of Latvia done by the OECD in 2019, as well as the Access to Justice for Business report for Latvia in 2018. And both reports have stressed that increased specialization in commercial affairs, increased possibility to tackle financial and other economic crimes can also improve judicial efficiency, effectiveness, also particularly when it comes to dealing with the some specialized areas such as bankruptcies and intellectual property. We also saw that there is potential for increased specialization in this area to enhance predictability of judicial decisions as well as the quality, but then also what is again extremely important, the responsiveness to the needs of business, because as we've heard from businesses in Latvia that some of the some of the biggest obstacles in resolving disputes included time and cost in dealing with the disputes. So strengthening specialization, strengthening efficiency, also looking at the justice system more broadly, including enhanced role for alternative dispute resolutions, for online dispute resolution, all have the potential to reduce costs to business, to the state and to the society. And certainly on the OECD side, we stand ready to continue supporting Latvia in this journey. So thank you so much for your attention, and I look forward to discussing these points further during the conference.
Paldies Tatjanai Teplovai, un mēs.
Thank you to Tatiana Teplova, and we go back to the minister now, and we could also begin our discussion around. So we've had a framework sort of sketched in about the most important elements that we should have, but perhaps we could start our discussion with the question of what are the practical steps that we should take to actually achieve this. Well, thank you, Mr. Daugals. I would like to thank all of the speakers of our first panel, and Madam Teplova is certainly expert of the field and very well versed in the situation in Latvia as well as the situation in other OECD countries at the moment. So thank you for highlighting the aspects that are most important for business, and which would be also applicable to business in Latvia. If we look at the size of companies in the world in general, most of them are SMEs. So I really want to thank also Ms. Kucina for doing such a good job in managing these issues at the the president's chancellery, and we are quite on the same page on most of these issues, and we are making a lot of effort in improving the justice system in Latvia, because our state president has a very good understanding of the system, of its history, and also a very clear vision of what the system should be. So we are together building our way to this economic development, not just as sort of an internal bubble for specialists. Obviously, we live in various bubbles at the same time, and this legal bubble does exist as it does in any profession, but we have to go outside of this bubble of ours, and we are doing this in the name of economic development. Mr. Neyman very clearly highlighted the practical cases, and also mentioning these illegal takeovers. And we do have very experienced lawyers, judges, experts, specialists at the ministry. But how have we come to this situation that we have cases that have been in courts for tens of years? We have experts that are very knowledgeable about them, but the time has come to actually resolve this situation. So, to mention some other fundamental values underlying the rule of law that have a direct impact on economic development, we have to speak about the clarity of the law. So a country governed by the rule of law is our objective, and the law is simply a tool. And how this tool is used is determined by the actual people using it. In recent years, we have undertaken the practice of consult before penalizing, and through this practice in all environments, and obviously people don't always violate laws intentionally. They have perhaps made a mistake, or they have not understood or misinterpreted the law because it has not been understandable. An example, for example, the accounting law. And so what all businesses have to adhere to, section 7.4, an external justifying document can be a document not containing signatures, and which is issued upon request by the service provider in the understanding of the service provision law, regarding the fact that the payment order has been fulfilled if the document shows that the payment order is valid and the user of the payment service is compliant. So all of this is a one sentence. And the question is whether this is a norm that is understandable to the user. Oh, most probably not. So unclear legislative norms are a sign of a low quality law. We've spoken about the opinion among institutions that the major challenge is actually drafting laws, and that often enough work is judged, or the work of an institution is judged by the number of legislative amendments that have been drafted. But this cannot be a benchmark, this number of amendments. So what we see here is also a trend where in the years when the productivity of in terms of the number of laws has been lower, the quality of them has actually been higher. So another thing I'd like to mention is that modern technologies give a lot of opportunities, and we can compare situations as well. For example, we have an app. I think today here we see also the how good the sound quality is, the picture quality is. It didn't used to be this way. So anyway, we have various apps on our smart devices that we use daily. First graders already know how to use them. So this is not a difficult tool to use, that although it employs the latest technologies, they are simple to use for the users themselves. And this is an analogy that we should also apply to the law. The rule of law can only function as a tool for economic development if it is applied understandably for entrepreneurs and business. Another important aspect is the professional quality of those applying law. So here we are speaking about competence, experience of judges, prosecutors. If the judge is competent in the legal regulations and case law, then the quality of their work, the quality of their decisions will be obviously higher, which will ensure stable case law. And this will also obviously produce all of the other effects that were mentioned by our other panelists. So we need to address the issue of providing equal opportunities for our justice specialists to improve their competence, improve their skills and knowledge. We are working on professional qualification raising system that would be an all-encompassing for the justice system. And this is definitely a priority for the justice system at the moment. Another thing that I'd like to mention, which also refers back to the length of court proceedings. So the more specialized the judge, the quicker the court proceedings would be. And as we heard from the OECD expert, that this is directly linked to public trust. The shorter the terms, or the quicker that cases are examined in the court, the higher public trust. Because the public does follow these issues, and public trust can be improved very quickly. I've seen that in just in the course of 1 year, you can improve public trust significantly. And in conclusion, a fair decision is an understandable one, and vice versa. We often hear the expression, especially as regards civil proceedings, that, well, one party will always be unsatisfied. I do not completely agree with this, because this is not an indicator. And people in Latvia are not so limited in their understanding that they have to assume that always one party is the losing side. There is a difference between the legal opinion and the rational and human opinion. Several years ago, I had someone come to me and tell me with frustration about a court case where a senator had replied to one of the parties saying that this is unfair. The senator had said, well, did you come here for fairness? because the court has nothing to do with fairness, especially in administrative cases. We work according to the law. If you want fairness, then go to the church. Obviously, this cannot be correlated because a court decision cannot leave someone feeling as if it is unfair. And the public sees this. So in conclusion, a court decision, just as a law, has to be produced in a way that it is understandable to people without specific legal experience, legal knowledge. And this is an indicator of high quality of court decisions to combine these two seemingly radically different values. So that would be my contribution to the discussion. Well, thank you, Mr. Minister. We have some questions that have come in for our panelists. So first, the first question is for Mr. Neimanis, that rationality is only possible if we have trust. So how can we promote trust in the justice system?
Sorry, I didn't hear the question, says the speaker. The question is, you mentioned that to rely on one's conclusions, on one's sound judgment is based on mutual trust, how to promote this trust. We all are born with an ability to make sound decisions with common sense. And during the time, we kept more and more sticking to written rules, losing our ability to rely on common sense. So our actions should be prescribed not just by the law, but also by common sense. And as the minute we become slaves, or I wouldn't say slaves, the minute we rely just on written law, we lose our ability to measure, to understand what is just and what is not just. We lose ability to apply our common sense. That might be legally correct, but sometimes it can become absurd. If a person is sticking to a letter, I don't know whether it has correlation with trust. I don't know. I believe more that in these situations, it becomes obvious for the biggest part of society, and this biggest part of society is losing its positive thoughts about this or that institution, in this case, the courts. I believe that many people don't believe that court judgments should be issued very quickly. We are not plumbers, and even plumbers could work longer, or road builders. It can take a longer time to build a road of good quality. But at a moment when it becomes absurdly lengthy, at that moment, we have a question. Does it make sense, or isn't it bizarre that something is taking so long? And at that moment, we lose faith in justice system. Thank you. A question to Madam Kucina. Isn't it a high time of starting investigation on unjust procurement procedures that the president mentioned in his inauguration speech? Thank you very much for the question, as well as for what my colleagues said, what Mr. Bordan said, and our president said in his inauguration speech, namely strengthening of justice and effectivization of these processes together with respective ministries, and we are doing that. But my conclusion today, thank you, representatives of OECD, thank you for your support. And we should be happy for these cooperation partners, for partners who know practice and law of almost all the countries, and they could give advice from their vast array of law and experience. And we can take the best, pick and choose, and apply what is most suited for us. Do have a look at these statistics. When preparing this speech, I looked at some statistic data. You know what we found? What I found? What we show to the society and to the world. If a judge in this survey can reply and say that our majority of judges said that my colleagues are not honest, what the society thinks, if the judges themselves think like that of their colleagues, how can we do something else or try to do something else if we ourselves do not believe in what we do and we do not believe in our colleagues? I compared our survey with other countries, with Norway, with Denmark. There were no answers from judges questioning honesty of their colleagues. Namely, no one in those countries replied that they do not trust their colleagues. They said, we believe in our colleagues, we believe in justice system. So those are 300, 500 responses. Those are indicators. And we are sometimes wondering why they have so good indicators. Let's begin with ourselves and let us, starting from ourselves, distribute this justice outside the system to the whole of society. It is obvious that the culture of justice is closely related to equality, to principles equality, to internal need, which goes and becomes external. Also this common sense, application of common sense and application of the law that will be further investigated in other panels. So thank you very much, Irena Kucina, representing President's Chancellery, Jānis Nīmanis, representing Constitutional Court, Jānis Bordāns, Minister of Justice, and Jelena Teplova, representing OECD. Now a technical break of 10 minutes, and then we will have the second panel.